Hi everyone, welcome to our webinar today. My name is Singh Jenkins. I'm a labor and employment lawyer at McInnes Cooper's Halifax office, and I'm joined today by my colleague, Ryan McCarville, who is a labor and employment partner in our Charlottetown, Prince Edward Island office. So today we're going to be talking about a hot topic, something that's come up a lot in the media lately, navigating layoffs in the time of tariffs. And with shifting US tariffs impacting Canadian businesses, a lot of folks are finding themselves in the unfortunate position of having to consider layoffs and other measures as a survival strategy. So we're going to be talking today about some of the legal implications of layoffs and what you need to know in order to better understand the risks with any decisions that you're making. So we're going to be talking about several questions today. For example, do you have the right to temporarily lay off your employees? What are the legal consequences if you don't have that right? Does a business downturn caused by tariffs frustrate your employment contracts? And what kind of management tactics can you use in the workplace to help get you through this time? With that being said, we do want the presentation to be interactive, so feel free to drop questions in the chat box at any time, and we'll try to get to those as they come in. So it's been widely speculated that persistent trade and tariff war between Canada and the United States could lead to significant workforce reductions and job loss in the most affected sectors of the Canadian economy. And tariff uncertainty is already causing a lot of disruption for a lot of businesses and forcing tough choices like having to cut staff, having to shut down a plant temporarily or completely, among other measures. And we've seen some examples in the media of this recently as well. So I think I was reading last week that GM is going to be laying off 750 workers at its Oshawa plant, and they cited tariffs as the reason for that. There's been several steel companies, one of the well-known ones, Algoma Steel, that have laid off employees, also citing tariffs. SheerTex, a pantyhose company, laid off 40% of their staff due to tariffs because they send so much product south of the border. And Stellantis, and the major auto parts manufacturer, recently had a 2-week temporary plant shut down. So we're already seeing a lot of examples, particularly in the manufacturing sector, where tariffs are already having that impact on the workforce. And so if we look across Canada, some places are going to be more heavily impacted than others. So we can see at the top of the list here is St. John, New Brunswick, which is slated to face the highest impacts as a result of tariffs. St. John, of course, being home to the Irving oil refinery, which sends 80% of its product south of the border, and also having forestry and seafood industries, which it heavily relies on to export products to the US. Similarly, we see Calgary, another oil town that exports to the US, being heavily impacted. And the last three, Ontario cities, being major manufacturers of cars and automotive parts, being impacted. So fair to say that, cities that tend to have a few major industries, particularly manufacturing, are probably going to be some of the most impacted as a result of tariffs, if not already. So that kind of brings us to, well, what should we do, and what can you do as employers in response to some of these tariff threats and risks that seem to come up daily? So in considering layoffs in particular as a strategy, Ryan and I are going to be going through some of the most common questions that you folks may have and that come up when you're considering making those decisions. So the first common question is termination versus a layoff. Are these things one and the same? And a lot of people and a lot of my clients tend to use these terms interchangeably. But from a legal standpoint, there are distinct and different meanings, particularly under employment standards legislation. So we look at the differences between a layoff and a termination. Generally, a layoff refers to a temporary interruption of employment, usually due to a shortage of work. And that's often the term that we see come up in minimum employment standards legislation is temporary layoff. So as the kind of term implies, the employee temporarily stops working, employer temporarily stops paying their employee, temporary obviously being the key word there. Whereas a termination is permanent. It's a permanent severance of the the employment relationship. Employee stops working for the employer for good, and employer stops paying the employee for good. Often, employment standards legislation will allow businesses to have short-term layoffs, after which a layoff is treated as though it were a termination of employment. So, for example, in Nova Scotia, businesses can lay off their employees for up to 6 days, so a pretty short period of time before it's considered triggering a termination, requiring the need for notice under employment standards legislation. And we'll get into that a little bit later in some more detail. The second question that commonly comes up is, do you have the right to lay employees off? And when we're considering layoffs, there's 3 sources of law that really inform what your rights are to lay off employees. So the first being the common law or judge-made law, and that would be court decisions that come up. The second being contractual, and so in this context, that would be either if you're in a non-union environment, that'd be your employment contracts with individual employees, or if you're in a unionized environment, that would be your collective agreement. And then finally, the third source of layoff rights is minimum employment standards legislation. So just starting with the common law or court-based law, courts have consistently held that a temporary layoff is going to be considered the same as a termination of employment. So this is true even if you are compliant with minimum employment standards legislation that allows you to temporary layoff an employee. So in other words, you're not allowed to lay off an employee without any liability simply because you're following minimum standards. There's still the common law in the background, which doesn't distinguish between termination and a layoff. They consider it to be a termination. So compliance with minimum standards legislation allowing you to temporarily lay off an employee is not going to be a defense to a common law claim for constructive dismissal. So we'll get to this, but it's important that in order to address this risk that is presented by the common law not distinguishing really between layoffs and terminations, that we have express provisions in our contracts, whether it's the employment contract or the collective agreement, allowing for those temporary layoffs. So looking at the second source of law, those contracts that I just mentioned, contracts generally are made up of what we call express terms. So those are terms that you specifically agree to in writing with your employees. And then there's what we call implied terms. So those are terms that the law will imply into the employment relationship. So for example, if you have a verbal employment contract with an employee, the law will imply into that verbal contract that the employee has a right to reasonable notice. So even though there's nothing in writing, it's automatically implied under the law. So when it comes to temporary layoffs, there is the possibility that either the express terms of a contract, or potentially, though a much harder argument to make, the implied terms of the contract could give an employer the right to temporarily lay off an employee. So with express terms, these would be found, of course, either in your employment contract or your collective agreement, and it'd be a specific clause that indicates that you as an employer can temporarily lay off an employee. And again, the key word being temporary, there has to be some kind of definition or bounds around the layoff. It can't be, we'll lay you off without until further notice. Like there has to be some kind of guidance as to when the employee will be brought back, so that it's truly a temporary layoff and not falling more into that termination category. So if your contracts do not have something that specifically allows you to temporarily lay off employees, then it is possible that this could be implied by law. And an implied right might be created, for example, from a past pattern or past practice of temporary layoffs. And usually this is industry based. So, for example, in certain sectors of the construction industry, it might be common to temporarily lay off employees between projects. And that might be kind of an industry or a trade custom. But of course, that's obviously going to be a much riskier argument for you to take as an employer, that you have an implied right to lay someone off without an express provision in writing, because if an employee challenges your implied right, then you'll have to prove the existence of the implied term through, if it's a court action, through court. And again, that can be risky, because it would require significant evidence of industry practice and mutual understanding of both the employee and the employer that there was that right to temporarily lay off folks. So all that to say, if there's no express right to lay off an employee in the employment contract and no basis to argue that there's an implied right, then your right to temporarily lay off an employee is very much restricted under the common law. So on the third source of law dealing with layoffs, we have minimum employment standards legislation. So that's depending on where you live, could be the Employment Standards Act, could be the Labor Standards Code. It's that legislation that sets out the minimum guidelines for employers. And as I said earlier, most minimum employment standards legislation will allow you to temporarily lay off an employee. The duration changes province to province. I know in Nova Scotia, it's 6 days, so a very short period of time in which you can lay off an employee before you trigger notice obligations under the Labor Standards Code. But it's important to note that there's still that common law presumption in the background that we always need to be thinking about, that a layoff is a termination. So again, the way to kind of address that concern or that risk so that you don't terminate hefty common law notice obligations is through express provision in your employment contracts. Oh, just one more thing on this slide, the mass termination requirements. So if you're going to be laying off a significant number of staff, so for example, if like GM laying off 750 employees, it could trigger possible mass layoff notice requirements. And these again will vary province to province. And this can impose additional obligations for notice. So for example, in Nova Scotia, if you're going to be terminating 10 or more employees in a 4-week period, your notice obligations are going to range from between 8 to 16 weeks. So it can be significantly more under employment standards legislation if you are going to be laying off large numbers of employees for extended periods of time. So in terms of consequences, particularly the consequences of laying off an employee when you don't have a right to do so, the big risk here is constructive dismissal. And so if your employment contract doesn't allow you to expressly lay off an employee, then the common law is going to consider the employee to have been constructively dismissed because, again, they consider a layoff and a termination to be one and the same unless you have an agreement with the employee. And that's really because a layoff is considered a breach of a fundamental term of an employee's employment, which then allows the employee to claim termination rates as if they had been expressly told that they were fired by their employer. And so that those risks, those liability risks for termination kind of vary, but it could be statutory severance, common law severance, which typically ranges 3 to 5 weeks per year of service. And if you're in a unionized context, possibly reinstatement as well. And notably, the existence of circumstances like the negative impact of unexpected and significant tariffs likely isn't enough to relieve folks of these consequences. And we have some precedents from COVID, in some cases from COVID, that kind of considered this issue as to whether a significant economic event can essentially create a right for an employer to lay off an employee. And what courts have found is that no, it doesn't create that right. It's still going to be considered, a layoff is still going to be considered a termination, regardless of the circumstances under which it arises. So the Ristanovic case here is a case out of Ontario. And essentially what the court found there is that even though the pandemic had significantly disrupted the employer's operations, what the court reasoned was that, there's so many adverse events in the world these days that can derail a business, and that doesn't justify unilateral layoffs. So the fact that an employer might experience significant business disruptions due to a pandemic or a similar world event doesn't necessarily give them the right to temporarily lay off staff without these staff's express agreement. And if they do, it'll trigger a constructive dismissal. And so similar results to that Ontario case were also reached in British Columbia with the Hogan decision as well. And so I think kind of the main takeaway from this so far is that it's really important to review your written contracts to see what is currently permitted with regard to layoffs and whether temporary layoffs are something that is addressed within those contracts, whether it's your employment contracts or the collective agreement. So with that, I'm going to turn it over to my colleague Ryan, who's going to be talking more about frustration of contract and also some tactics and guidance on how you can implement temporary layoff provisions in your contracts if you don't already have those.
Thanks, Jennifer. Before I get into the substantive portion of my presentation, I just want to give a shout out to her. Jennifer is 8.5 weeks or months pregnant, and her last day of work is next Friday. So I have no doubt she's kind of busy transitioning all her files as well. So I really appreciate her joining this session in what I'm sure is a busy time period for her. And just to kind of emphasize a few points of what Jennifer Jennifer said there. With respect to employment standards legislation in most provinces, if not all provinces, does allow for temporary layoff, but an employer can't just point to the employment standards legislation and say, there you go, that employment standards legislation allows me to temporarily lay off an employee in these circumstances or for this long of period. That's a defense to a complaint under employment standards legislation, but it's not going to be a defense to a wrongful dismissal lawsuit. So you need to keep that in mind. And then, as Jennifer said as well, there is case law that has found that temporary layoffs are permitted in the absence of an express term in the employment contract. So it can be implied into certain contracts of employment depending on the industry and the past practice, but relying on an implied term in a contract is risky for an employer, and you're going to have really, really good evidence that it is an implied term to go that route. So I just wanted to kind of highlight those 2 points. I'm going to be talking about frustration of contract, and then also provide some advice on those of you who may be affected by tariffs as well, and how to mitigate that risk. So you could just go to the next slide there, Jennifer. So frustration of contract is a basic principle of contract law. It's where an event outside of the control of the parties makes the contract impossible to perform, or so radically different than what the parties intended the contract to be, and so the contract can be said to be no longer exist or binding. We see this concept in employment contracts as well as commercial contracts. In the commercial contracts, a natural disaster or a law suddenly changing may frustrate the commercial contract, and therefore the parties can walk away from that contract. In the employment area, typically where we see frustration of contract is with respect to employee medical conditions. So if an employee has a medical condition that prevents them from working and doing any job, and you're unable to accommodate them under human rights legislation, and there's no they're unable to return to work at any point in the future based on the medical information that you have. In those circumstances, the employment contract is seen as frustrated. It's unable to be performed, and the employment relationship can come to an end in those circumstances. And then the other area in the employment law that we saw come up was in COVID. And so you can just go to the next slide there. So in COVID, many employers face significant economic pressures and downturns in their business, and as a result of that, began terminating employees' employment or laying them off. And we saw many cases come out of COVID where businesses did that and claimed frustration of contract, claimed that the pandemic was outside of their control, and therefore we don't have to give reasonable notice of termination or termination notice to those employees. And there was lots of cases coming out of COVID. And one thing that became apparent from those cases is that it is a high bar for an employer to establish frustration of contract. Temporary economic downturns or slow customer demands, in many cases, that's not going to be sufficient evidence to prove frustration of contract, because, as I said, it is a fairly high bar on an employer to establish that. In the Verrigan and Ensemble Travel Limited case, in that particular case, there was the employer operated a travel agency, and they temporarily laid off a number of employees, including the plaintiff in this particular case, and they had an initial return date of June of 2020, and then that return date got pushed out or extended again, and then they eventually terminated the employee's employment on the basis of frustration of contract. So they didn't pay her any reasonable notice or provide her any reasonable notice of termination. And in that particular case, the employer claimed that as a result of the COVID-19 pandemic, there was a global collapse of the travel market. Part of the employee's role was to travel as well, and that the COVID-19 pandemic was outside of their control, and the terminations were necessitated in order for the business to continue to survive through the pandemic. Um, the, uh, the British Columbia Supreme Court, however, disagreed with the employer on that and decided that the contract was not frustrated due to the pandemic. And while the court acknowledged that the travel market had experienced a significant downturn or collapse, which made it more difficult for the employer to perform their side of the employment contract, it found that not all of the business loss was permanent, and the employer had rebounded and had actually added new employees after the pandemic. So based on those facts, the employer was unable to prove frustration of contract, and the employee was entitled to reasonable notice damages, and so she was successful in her wrongful termination case. Sort of the same situation in the Slater case. In that particular case, the employer operated a news paper, initially placed the employee on temporary layoff, and then eventually terminated his employment and claimed that the pandemic resulted in a drop of revenue, and that as a result of that, the employment contract was frustrated. Ultimately, just before the trial, the day before the trial, in fact, the employer abandoned that position and no longer took the position that the employment contract was frustrated. And so that wasn't an issue in the case, but the court had some interesting remarks for the employer in that case. Uh, the court said that the employer acknowledges now that it did not have the right to dismiss the employee without notice or compensation after 39 years of service. And the court went on to say you can't treat people that way even during a pandemic. And so basically, you read into that decision that the employer was sort of using it as an excuse in some ways to end the employment without providing the necessary reasonable notice of termination, and the court awarded 22 months pay to that employee. So certainly ending the employment relationship by not providing, based on tariffs and based on COVID, was risky for many employers. And you're going to really have to prove uh, uh, you're going to have good evidence if you're going to rely on the doctrine of frustration of contract. And the case law suggests that sort of economic downturns or slow customer demands in many situations is not going to be sufficient evidence to prove frustration of contract. So we'll go to the next slide there. So how can you address the right to temporarily lay off employees? What tactics can you take as an employer to mitigate the risks of potential economic downturns or slow customer demands? Layoffs are very different in a unionized and non-unionized environment. In a unionized environment, typically the collective agreement will anticipate layoffs. It will provide a framework for how to proceed with layoffs. It will actually define what a layoff is. And so if you're in a unionized workplace, your first step is to review the collective agreement to determine what the framework is for laying off employees. Um, um, and that will sort of guide how you go about doing that. It is prudent to communicate with the union, and possibly, depending on how impacted your business is, if you're in a unionized workplace, you may want to negotiate a memorandum of understanding with respect to layoffs, because you may have language in the collective agreement around layoffs and the order of seniority that it is to go in, and bumping rights and their ability, employees who are laid off, displacing other employees. But you can also reach an agreement with the union and collaborate with the union on layoffs as well. So it certainly doesn't hurt to reach out, if you're contemplating layoffs, to reach out to the union and consult with them for their thoughts and possible creative options with respect to layoffs. And then if you do not, if you proceed with layoffs without that consultation, without their, without entering into a memorandum of understanding with them, you should prepare for grievances from the union with respect to your ability to lay off employees under the collective agreement. Okay, we'll go to the next slide, Jennifer. So as Jennifer said, in a non-unionized workplace, layoffs are considered constructive dismissal unless there is an express or implied term in the employment contract. And so on a go-forward basis, you can certainly amend your employment contracts to include an express right of the employer to place the employee on temporary layoffs. And we started to see this more and more frequently after the COVID-19 pandemic. Prior to that, I didn't, in a lot of the contracts that I would review or consult on or draft, I didn't see language and was not preparing contracts with language around temporary layoffs. And certainly that increased in frequency more after the COVID-19 pandemic. So more and more contracts we're seeing and drafting now that have a specific clause in them for a temporary layoff that says that the employer reserves the right to place employees on an unpaid temporary layoff due to a shortage of work, business restructuring, force majeure, or any other reasonable cause. The clause should reference applicable employment standards legislation as well. So it should say in accordance with applicable employment standards legislation. And then it should also reference that the individual will be deemed to have resigned from their employment should they fail to accept a recall of employment. One strategy, if you're the type of business that may be affected by tariffs now or in the future, or is a business that has sort of cyclical customer demands, or is susceptible to economic downturns, include temporary layoff language in your employment contract that specifically allows you as the employer to lay off an employee for a period of time and it be unpaid. The clause needs to indicate that it is temporary. Otherwise, a permanent layoff is, of course, a termination that would entitle an employee to notice of their termination. And as I said, the clause should also indicate that, should include a statement that the employee will be recalled when work becomes available. As with any employment contract clause, it's going to be, in the event it is vague or ambiguous, it's going to be read against the employer, or it could be found to be void. So be sure to be clear with respect to the drafting of the clause. Do not reference that it's permanent or indefinite. As I said, that would be considered a termination. And the clauses should not also provide a definitive duration or recall date. You as an employer want to retain some discretion to determine the length of the layoff. And often when you're laying off an employee, you don't know how long the layoff's going to last. You don't know how long the economic downturn or poor customer demands are going to last. So you want to be able to decide how long that layoff is going to be, depending on the situation that you're facing. Okay, we'll go to the next slide. So you can certainly include that temporary layoff language in your new employment contracts for new employees. With respect to current employees, um, to implement new terms of employment, you have to provide, for the contract to be enforceable, you have to provide something of value to the employee in exchange for signing a new employment contract. You can't just, as an employer, if you put a written employment contract in front of an employee that varies the terms from their previous employment contract, and do not offer any additional salary increases or vacation or something else of value, that new employment contract is going to be unenforceable, because as an employer, you need to provide what's called consideration in exchange for signing the new employment contract. So something of value. So if you're considering implementing new temporary layoff language for new employees going forward, that's fine. But if it's for your current staff, you're going to, for that contract to be enforceable, you're going to have to provide them some additional value or compensation or signing bonus in exchange for signing it. Your other option is to provide advance notice to them that the previous employment contract will be coming to an end, and effective on some future date, this new employment contract is going to apply. So you're essentially terminating the old contract and providing them with a new employment contract. So again, you can either provide them something of value, or you have to give that reasonable notice equal to what the termination notice that they would be entitled to if you're going to have an enforceable employment contract for your current staff. If you have language in your employment contract that allows you to temporarily lay off employees, or if you have evidence that in the industry that you're in, the employee has an implied term that entitles you to temporarily lay them off, you provide what's called a notice of layoff. It's similar to a termination letter, but it's a layoff letter indicating that you're temporarily laying them off from their position. So you would indicate in that letter that the employee is being temporarily laid off. You would indicate the reason why that was, and in this particular case, it would be tariffs. You would, and ultimately a downturn in business. You would refer back to, if you had a clause in the employment contract, you would refer back to that clause in the layoff letter. You would indicate the date that it commences, and that you intend to recall them within a specific time frame. That time frame can be extended as you monitor the economic position of your business, but you should include a specific intention to recall them within a particular time frame. There's plenty of case law out there where employers have laid off individuals indefinitely without any guarantee that they would be recalled in the future. And that is, in essence, a termination of employment. And it would be, your business would risk a wrongful dismissal lawsuit as a result of that. So we'll go to the next slide there. So that's what happened in this particular case. This individual was verbally advised that he was placed on furlough for an indefinite period of time, and was not provided with an explanation of what that meant, and was not provided any letter relating to that layoff. So he was ultimately placed on furlough as a result of a lack of work, and eventually initiated legal action against the employer for wrongful dismissal, and was successful in that legal action. So if you are going to proceed with a temporary layoff, it's important you do it correctly, and that you put the reasons in writing, and that you refer to it as a temporary layoff, and provide an overview as to the potential for recall as well, or your intentions to recall. In terms of returning employees to work after a temporary layoff, certainly you want to monitor the economic downturn. The expectation is that when the economic climate improves, that the individual will be recalled, and if they're not, then that could be viewed as a termination of employment and not just a temporary layoff. We have on the screen there maintain benefits if possible. That's to demonstrate that the layoff truly is temporary, and that you do intend to return them to back to work when you're able to, and it's also to lessen the economic impact on the employee as well. Um, and as I said, return the employee to work once the economic conditions have stabilized, and the employee is entitled at law to be placed back into the same or a suitable alternate position after the temporary layoff period ends. Placing them in a lower level position, or altering their providing them with less pay upon their return, could be viewed as constructive dismissal, and there's a risk of a constructive dismissal lawsuit as a result of that. And then lastly, maintain communication with the employee throughout the temporary layoff period. If employees continue to be communicated with, then they appreciate that, and they are more likely to believe that it's being done in good faith and not for nefarious reasons. So ensure to maintain communication with those employees that you've temporarily laid off, and keep them apprised of the status for potential recall. As I said, when you do temporarily lay off, if you do temporarily lay off employees, don't make comments to the effect that the employee is not likely to return. Don't characterize the layoff as permanent or indefinite or until further notice. Those types of comments could be viewed as terminations of employment, and that you don't have an intention to simply just temporarily lay them off, but permanently lay them off. Don't use a layoff in bad faith. And employees should be recalled once the economic position of the employer has improved. We'll go to the last slide there. So in terms of advice for those employers facing potential tariffs, or facing tariffs that will result in laying off employees, probably the best piece of advice is to have an employment contract for all staff that allows, with a termination clause, that allows you to terminate their employment by some reduced amount. So An employer is entitled to have a termination clause that limits the amount of notice to employees on termination to the statutory minimum. And that can result in a significant reduction in liability when or if you do have to lay off or terminate staff. So in PEI, for example, an employee with 9 years of service, depending on their age and position, at common law, they could be entitled to between 6 to 12 months reasonable notice, maybe a little more, maybe a little less, depending on their age and position. With a properly drafted termination clause in an employment contract, that liability can be reduced down to 4 weeks. So a significant savings for you as an employer with a properly drafted termination clause. And then rather than decide whether to temporarily lay off an employee um, or terminate their employment, you can simply rely on the termination clause and terminate their employment, um, uh, given that your liability is significantly less. So that's number one, is have a termination clause in your employment contract for non-unionized employees or excluded employees, and that could significantly reduce your liability. The second advice is to, if you're the type of business that may face changes in customer demands or has a cyclical demands from customers, include temporarily layoff language in your employment contract that allows you to lay off an employee temporarily under certain circumstances. And that will then allow you to, if you have that express term in an employment contract, that will allow you to actually proceed with that if you're ever faced with a situation where that becomes necessary. And then the third piece of advice is to start planning now. If you believe that you may be facing an economic downturn in the near future, consider providing notice of termination now or working notice of termination to staff now, where they continue to work during the notice period and then their employment will end on some future date, or at least start looking at your workforce and deciding where things might go. And I know that tariffs have been a moving target, but certainly it'd be prudent to start planning now on potential terminations and updating your employment contracts to include that temporary layoff language, and ensuring that you have a termination clause that lowers or reduces your potential liability in the event you have to terminate the employment of employees. So that was all that. Those were all the slides that we had. Jennifer, did you want to add anything to my portion of the presentation?
Yeah, I think that's all extremely helpful advice, Ryan, particularly the point on ensuring that, you know, if you're going to be looking at your contracts in any event for a temporary layoff clause, also keep an eye out and you have the termination clause reviewed, even if you already have a termination clause, because we've seen a lot of changes, particularly here in Nova Scotia, in recent years with case law. Um, uh, Being harder on termination clauses. So if you're going to do a review for temporary layoffs anyway, very prudent advice from Ryan to do that review and inclusion of a termination clause as well.
Yes, that's a great point, Jennifer. There's been lots of case law, particularly coming out of Ontario, which have invalidated certain termination clauses. So if you are looking to include temporary layoff language in your employment contract, it's a good idea to get um, the termination clause and other sections of your contracts updated as well to ensure that they are enforceable.
And I think we had so I don't see any questions in the chat box, but if folks do have questions, feel free to post them in there. I know there were a few submitted ahead of time, and I think one of the questions was for tenure plus employees, what kind of notice of layoff needs to be provided. And so I think this is a question for Nova Scotia, because here we have restrictions on the ability to lay off and terminate employees with greater than 10 years of service. So the amount of notice, if you do have an ability to lay off a 10-year plus employee, is going to be 8 weeks statutory notice. But with a 10-year plus employee here in Nova Scotia, you don't get that automatic kind of temporary layoff right from the legislation. You have to show that there's essentially been a bona fide or genuine position uh, elimination that has resulted in the need to lay off the employee. So there's kind of additional things that you have to prove in order for layoff of a 10-year plus employee to be valid. Otherwise, they can apply for reinstatement rights, which is kind of a unique feature here in Nova Scotia.
There was another question as well, Jennifer, around understanding the process and requirements on termination, not just temporary layoff of staff, but terminating staff due to a loss of business. And we spoke about that during the presentation, but just for the sake of clarity, a loss of business or economic hardship in most situations is not going to allow an employer to terminate an employment contract or to end the employment relationship without providing an employee with notice of their termination. It may, in some circumstances, depending on the particular business and the circumstances it faces, but in most circumstances, that is going to be if you have to lay off employee or terminate employees as a result of a downturn in business, that termination is going to be a without cause termination, and the employee is going to be entitled to notice of that termination, either contractual notice of termination if they have a clause in their employment contract, or reasonable notice of termination if they do not have an enforceable termination notice in their employment contract. You can provide working notice of termination. So you would provide an employee with a letter saying you are terminated on some future date. And during that time, you're to continue to come into work. You'll receive your normal salary. You continue to work your regular schedule. So you do have that option of providing working notice, or you can simply pay the notice out to the employee. So the employee doesn't come into work, but they receive their notice of termination.
Yeah, good point. And I think one other question that came up in some of the um, materials before the webinar was with respect to unions and unionized environments, and what kind of besides temporary layoffs, what kind of other measures could folks consider um, uh, as part of their kind of holistic plan to address tariffs. Yeah, so Ryan, if you want to
Sure.
speak to that.
Yeah.
Yeah.
Yeah. The alternatives that companies in a unionized environment can use in lieu of layoffs is in part going to depend on what's in the collective agreement, and in part going to depend on whether they can enter into a memorandum of agreement with the union to restructure how they operate. So it's a bit of a difficult question to answer without more details, but I would say if you're a unionized business and you're looking to avoid laying off employees, then consult with the union on how you may be able to restructure schedules or reduce the total number of working hours of your staff in order to sort of survive your current current economic position. So it comes down to consultations with the union and possibly entering into a memorandum of agreement with them, depending on the creative solutions you might be able to come up with.
Yeah, great point. I don't see any other questions for us in the chat, but if folks do have questions after the presentation, please feel free to reach out to Ryan and I. I was hoping our emails would show up on the screen there, but they're probably in the presentation materials. So we really do appreciate everyone joining us today for the webinar, and please do feel free to reach out if you have any questions or follow-up.
I do see one question here, one last question in the chat. It says, if providing a new employee contract to include the layoff language for existing employees, and there's no additional values provided, so no signing bonus or additional wages, what is the length of reasonable notice for an employee to sign, and what if they refuse to sign? Great question. So the length of reasonable notice is going to depend on the Bardell factor. So it's going to depend on, first of all, I guess, whether the employee has a termination clause in their current employment contract. And if so, that length of notice may apply. If they don't, then the Bardell factors are going to apply, and that reasonable notice is going to depend on their age, length of employment, and position and availability of positions similar to theirs. So the amount of the notice is going to it's going to depend. But what you would do in that circumstance is you would write to the employee and present them that new employment contract and indicate that it's going to take effect on that future date. If they refuse to sign it, then what you do is you can terminate their existing employment contract by providing working notice and working notice for that notice period, and provide them with that new employment contract and say, this is still, you could still sign this. This is still being offered to you. And if they refuse to sign that, they're likely going to be considered to have failed to mitigate their damages, and you have provided them with reasonable notice of termination in any event. So again, provide them with that reasonable notice that here's the new employment contract, and ask them to sign it. If they refuse to sign it, then the safest thing to do is to formally terminate their employment under the old terms by providing that working reasonable notice.
Yeah, great answer on that, Ryan. And just one other thing to add is that, so I know we mentioned providing advance notice or providing something of value. Oftentimes what many folks can find is kind of the least cumbersome way to implement those new contracts is during an annual raise process where employees being given something of value, they might be getting a salary increase, and presenting the employment contract with the revised terms at that time can be a little less, I guess, obvious of the changes that are trying to be made in the workplace, and a little smoother. So just something to consider as well, kind of as part of a natural raise process.
That's a great point, Jennifer.
Perfect. Well, that's it for the questions. Again, appreciate everyone jumping on the webinar today, and hope you have a great rest of your day.
Thanks, everyone.